Welcome everybody to today's webinar. Today we are talking about dealing with a death in British Columbia. We have three incredible guest speakers, Amy Mortimer, KC, Alison Sharkey, and Ali Huggins. My name is Paula Price. I'm with the People's Law School, and I will be your host and moderator for today. What we will be talking about today is preparing for the death of a loved one. We will be talking about dealing with the logistics and aftermath of a death, and finally, managing grief and the emotional difficulties that surround a death. What you can expect, we will be providing answers to common questions. It is legal information, not advice. If what you're looking for is the law as it applies to your unique set of circumstances, we would invite you to reach out to one of our lawyer speakers, Amy Mortimer or Alison Sharkey. Their contact information is on the screen, or of course, another lawyer. We also have a counselor. So if you are looking for guidance in particular as it applies to your particular situation, we would invite you to reach out to Ali Huggins. Her information is on the screen, or another counselor. And also just to mention that the information that we're sharing is current as of today. We, the People's Law School team, are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we would invite everybody who has joined us to reflect on where it is that they are joining us from today. We would also like to acknowledge and thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose financial support makes it possible for us to produce these webinars. Finally, I'm pleased to introduce our guest speakers, starting with Amy Mortimer, KC. Amy is a lawyer and co-chair of the Estates and Trust Practice Group at Clark Wilson in Vancouver. Amy is a return speaker. This is her fourth webinar with us. We are delighted to have her back. Not only does she have the technical expertise in this area, but she is also really practical and very empathetic. We are really delighted with the approach that she takes to these very sensitive matters sometimes, and we're thrilled to have her here with us today. Welcome, Amy.
Thank you, Paula, and thank you for your kind words.
Thank you. And with us as well is Alison Sharkey. So Alison is a lawyer also with the firm of Clark Wilson in Vancouver, and also practices in the area of estates and trusts. We are delighted to have Alison with us. She supports her clients in the estate planning and administration process, and she helps clients alleviate their burdens dealing with the end of life issues, giving them the peace of mind knowing that their legal affairs will be taken care of. So Alison, thank you so much for joining us here today.
Hi, Paula. Thanks so much for having me. Happy to be here.
Wonderful. And finally, we have Ali Huggins. Ali is a registered clinical counselor based in Kelowna. Ali has expertise in anxiety, depression, grief and loss, trauma and life transitions, and over 7 years of experience as a mental health professional for various nonprofit organizations. She comes highly recommended. We are so thrilled to have Ali here with us today. Ali, welcome.
Thank you so much. I'm excited for today.
Wonderful. We are going to get started with our questions. And the first question is for you, Amy. My mother has Alzheimer's and it's advancing rapidly. What questions should I ask her now so that we can plan for her death in accordance with her wishes?
Thank you, Paula. And keeping in mind that I'm going to be speaking from a legal perspective, you will also need to deal with the emotional part in that transition, and Ali will be discussing those types of issues moving forward today. But what I think is really important here is to find out what planning mom has already made. So this is going to depend, and your approach is going to depend on what stage her Alzheimer's is at, or her dementia, and what her capacity is. So obviously you're going to use your own good judgment, but if you can find out what documents she's already prepared, leading into this decline, what she hopefully will already have is an enduring power of attorney, which is the document that will let you make decisions, or the attorney make decisions for her from a legal or financial perspective when she's no longer able to do so. Hopefully she'll have a representation agreement in place, which will let the representative make her medical decisions for her if she's no longer able to do so. She may have an advance directive in place, which is going to talk a little bit about her wishes for her care when she's maybe not able to express them any longer. And also find out if she has a will. Has she already prepared a will? And so I would find out whether she has those documents and whether she's comfortable providing you with the originals. It may be she keeps these important documents in her safe deposit box, but the reality is you're going to need to access them, or the person named in those documents is going to need to access them. And sometimes if you know that mom is going to be declining and maybe not able to get those documents herself, if you take them out beforehand with her consent and keep them somewhere safe so that when you need them, they're available, that would be helpful. You should also find out if she's made arrangements at a funeral home to find out whether or not those plans are already in place, and if so, get a copy of that contract. I'd also talk to her about how is she paying her bills right now, and find out whether or not you need to set up some automatic payments through her bank and what the banking arrangements actually are to make it easier for you to help care for your mom as she declines. I see this as well that this is in an ideal circumstance where there's no family tension, but where there is family tension, then I recommend that you bring in all of the siblings or the spouse of mom to make sure that everybody is on the same page of figuring out what mom wants and how you're going to get to that so that you're all in it together. Because it's been my experience that when there is a fracture, or even the beginning of a fracture in family dynamics, that when there isn't full transparency and full communication, human nature seems to be that people will fill in the worst case scenario rather than the best case scenario. So I would remind you to keep your lines of communication open, not only with mom, but with all of the loved ones as well.
Beautiful. Thank you so much, Amy. This next question is for you, Ali. My father is becoming increasingly frail. I want to talk to him about the inevitable, but I struggle to bring it up. What can I do to prepare for this difficult conversation?
Thank you. I think that sometimes when a conversation is really uncomfortable, we feel guilty, or we feel like we shouldn't be having that conversation. And usually it's quite the opposite. I think in order to prepare for this, you have to accept that it may be, probably will be uncomfortable. People have sort of a framework of like, okay, the worst case scenario, the best case scenario, and it often falls somewhere in between. The way you can prepare is to sort of make a list in advance of like intentions, things you want to get out of the conversation. If you do have siblings and there aren't fractures, as Amy was mentioning, because that can happen often, getting together to talk as a group can be really helpful. I mean, there's 100% chance that we're all going to die. And I know that there is a stigma around sort of bringing up the financial complications of that and getting your things in order in advance. But it's definitely crucial to have those conversations. It can also really save relationships if you do address these things after the fact. I know sometimes, like, if finances aren't organized, which is a part of this conversation, siblings can have some trouble down the road. You can also really use open-ended questions with your father. It's a caring act, what you're doing. You're not being bad. You can say, what would you like? What are your wishes? How can we support you? I think too, more and more people are open to euthanasia, medically assisted dying. So we are sort of moving past the stigma where, we just sort of don't talk about it until it happens. I think too, sometimes people die suddenly. And I think if you do have that prior knowledge that, someone is nearing the end or they're starting to show signs, you know, having these conversations when they're sound of mind is really important. And you know, the grieving process starts when you see parents aging. So it's not a linear, simple process.
Beautiful. Thank you so much. I think I appreciate what you said about going into the conversation with your goals in mind, right? The intentions in mind. What are the topics that you'd like to discuss? Because that can be really difficult, and at least then you've got a roadmap, something that you can fall back on. Allison, this next question is for you. My best friend named me as the executor of her will. I'll be overwhelmed with grief when she passes. What arrangements can I make now to make her death more manageable? Oh, we've got a mute button.
Sorry. Thanks, Paula. This is a really important question to ask because being an executor is a big job and it can be a lot of responsibility. So when it's something you're having to deal with along with sort of the emotional challenges associated with losing someone close to you, it can feel overwhelming. So there are some things that you can do in advance to sort of help things move along more smoothly. The first is to have open lines of communication with your friend, and make sure that you have a copy of her will. That can be a big help, so you get an idea of what kind of work is going to be involved in the estate. Is it going to be really simple and straightforward? Is it going to be maybe a little bit more complex? And knowing whether it's going to be simple or complex might affect the other steps you take in planning for how you're going to manage this. The second thing you really want to do is ask your friend for a list of their assets and their debts. This could be a bit of an uncomfortable conversation, but ultimately, when you're acting as someone's executor, this can be one of the most challenging and time-consuming parts of making an application for probate, to probate the will, is gathering all of that information about all of the assets and the debts that the person had. So if you've got that kind of lined up already, that can take a lot of the weight off when the time comes. Something else to consider is if you really feel like you're not going to be able to handle this, you might want to talk to your friend about that and say to them, hey, I feel like I'm going to be overwhelmed with grief when you pass away, and this might not be a job that I'm able to take on. And your friend might have somebody else who could be better suited. And so finally, this is kind of an after the fact thing that you might be able to do, but keep in mind that you don't have to take on the role of executor, even if you've been appointed. It is possible for you to renounce that role if when the time comes you feel you just aren't able to do it. You can sign a notice of renunciation. The paperwork for that is pretty simple. You just want to keep in mind that that's something you want to do before you start handling the estate, because there can be issues if you've done what's called intermeddling.
Beautiful. Thank you so much, Allison. This next question is for Amy. Amy, my uncle is in the hospital and wants to come home for his last days. What do we need to, who do we need to notify after he dies? Are we allowed to have our church minister come and give a blessing?
Yes, and this is something that we see happen. There are lots of people who want to pass at home. And I'll just address first what happens while uncle is still at the hospital, but perhaps he, while the arrangements are being made, he may pass at the hospital. And so you are able to arrange for your uncle's minister or the spiritual advisor to come in. Some hospitals will have the social worker available to help facilitate or coordinate that. They might have some ministers or other spiritual advisors that may be available if uncle's usual one isn't available. So talk to the hospital team to see if there is somebody that can assist on that front. And then the key piece that you'll need to know for either uncle passing in the hospital or at his home is who is the funeral provider? Who is that going to be? Because if uncle passes at the hospital, the doctors and nurses will take care of all of the steps of moving him, pronouncing death, and then ultimately either they or you will make the arrangements to move him to the funeral provider, the funeral home. If uncle is being discharged to pass at home, then the doctor is going to fill out some forms. The doctor may be filling out a form to say that like a DNR, do not resuscitate, don't give CPR to uncle, and also a notice of expected death. And that notice of expected death is given to the funeral home by the hospital so that they know that uncle is going to pass in the foreseeable future. And when that happens, there's a person who's designated, it may be you or his spouse or child, who is then authorized to contact the funeral home directly to come and arrange for that transportation without the need of, calling the ambulance or calling in a doctor to make an official pronouncement of death. You're still able to contact a doctor or a health nurse to come in and make that pronouncement if you like, but it's not necessary. You can just have the funeral home make the arrangements to come and move your uncle. If you are doing that, in addition to making sure that the paperwork is taken care of at the hospital, I also recommend having a conversation with the funeral home. Make sure you know how to contact them outside of business hours. Make sure you understand how long it will take between the time you call for them to come and pick up your uncle until the time they expect to arrive, and make sure that's all comfortable for you. So, and then obviously the church minister can come and give a blessing at your house and facilitate all of those pieces as well. And in the way that the minister normally does. This is something that's very common, and I've seen a number of times of spiritual advisors of all denominations. They do this on a regular basis, so they can provide you some guidance as well.
Wonderful. Thank you so much, Amy. This next question is for Allison. Allison, my wife died unexpectedly in her sleep. What do we do with her body? Will she need to have an autopsy? And what about organ donation?
Thanks, Paula. So what's different about this situation as opposed to the situation that Amy was just discussing is that the death is unexpected. So in a situation where somebody dies unexpectedly in your home, what has to happen is a pronouncement of death. And so what you should do right away is call emergency services, so call 911, or call the coroner services, and then a medical professional will come and will make a pronouncement of death. So in terms of the body can't be removed until that pronouncement of death is made. But once it's made, the person who is her legal representative, who would either be the executor in her will or the next of kin, can direct the body to be moved to a funeral home. In terms of an autopsy might be required in these circumstances because the death was unexpected. You can also request an autopsy. The family can request an autopsy if they want to know the cause of death. For organ donation, you would want to check to see if your wife was a registered organ donor. And if she was a registered organ donor and there was nothing to suggest that her consent to organ donation had changed before her death, then you could contact BC Transplant for the next steps in terms of having her organs donated. If she wasn't a registered organ donor, but she had expressed a wish to have her organs donated, whether that was in her will or verbally, then you could also contact BC Transplant for next steps.
Beautiful. Thank you so much, Allison. This next question is for Ali. I was under a lot of pressure to take care of my ailing brother. I feel a tremendous loss now that he's gone and guilty that I didn't do enough to help him, and yet also relieved that his suffering has ended. Does that make me a bad person? How do I deal with my conflicting emotions?
Thanks, Paula. I'll start off by saying, no, it does not make you a bad person. When we deal with death and grief, we're going to feel lots of different emotions at once. And, it makes sense that you would feel relieved if someone's suffering has come to an end. There is no one way to grieve. I think, sometimes some part of grief is this longing to sort of fix it or undo it, or, like, is there something I could have done that would prevent these horrible feelings? And I think a lot of the time people who are very analytical and like to solve things in their heads, sort of go down the rabbit hole of trying to get around just feeling the pain of the loss. So I would definitely encourage someone going through that to really just let themselves feel what they're feeling. Talk about it, name your emotions, make sure you're reaching out for supports. I think, our relationship with our loved one matters a lot too. I think that, sometimes we go back and analyze the relationships, things we didn't say, and sort of doubting ourselves. And that is part of the process as well. I think there's a lot in death and grief that we just can't control. So for people who really like to be in control, it can be difficult to really like let go of that and just feel.
Beautiful. Thank you so much, Ali. Allison, this next question is for you. My siblings and I each have a different idea in mind about the kind of funeral we want to hold for our father when he passes. Who's responsible for making the funeral arrangements, and who will pay for the funeral?
Thanks, Paula. So I'm going to answer this from the legal perspective. So legally, the person who's responsible for making funeral arrangements would be the executor of the dad's will. If there is no executor, then it's going to be the next of kin in order of priority. So if dad has a living spouse, then the spouse is going to be the person who has that right to make those arrangements. But if there's no spouse living, then that right passes on to adult children. So in this situation, if there's no spouse living, we might be facing a bit of a conflict because it would be the children together who have the right to make that decision. But if they can't make the decision together, then it's actually the eldest child who becomes responsible for making the funeral arrangements. In terms of who will pay for the funeral can be paid for out of the estate. And most financial institutions you can be reimbursed from the estate for those funeral expenses. I should just note one additional thing, which is that if your father expresses in his will that he has a preference with respect to cremation or burial, that wish is actually legally binding. And so the person who's making the funeral arrangements does need to follow his wishes in that regard. But other wishes, like, for example, what the sort of funeral ceremony is going to look like, those are not legally binding, but it is a good guide for what you should do, and every effort should be made to carry out the deceased's wishes.
Thank you so much, Allison. This next question is for Ali. Ali, I lost my brother a few weeks ago. The best way I know to manage is to keep living life as normally as possible. Am I grieving properly?
That's a great question. Thank you, Paula. I get that. I get asked that very, very often in private practice. Am I grieving properly? And the answer is there is no answer. There's no textbook way to grieve. Everyone will grieve very uniquely. I think a better way to frame that is, am I processing this in a healthy way or an unhealthy way? So, in this case, it's okay to continue to live your life normally. I think what matters is that you're paying attention to your feelings rather than avoiding them. You know, you can live your life normally and still, you know, sometimes like a song will come on the radio that reminds you of your loved one, and you'll cry, and then you know you'll get it out, you'll show up at work and continue the day. That's okay, that's very normal. The sort of like grandmother of grief was Elizabeth Kubler-Ross, and she in sort of like the late 60s, she had the 5 stages of grief. A lot of people are familiar. It's denial, anger, bargaining, depression, and then finally acceptance. Recently, there's been a lot of criticism over that, and it's sort of been challenged because it's not everyone experiences grief in a linear way. Some people skip steps, some people, you know, take longer than others, or they don't go through any of the steps at all. You know, sometimes we also grieve in advance, right? Like, for example, if someone has a high-risk lifestyle and they're struggling with substance abuse and they pass, you know, it might be a different experience for us because we've been preparing for that. So, you know, part of the process as well is sort of remapping, part of the grief process is remapping where this person exists to us within space, time, and closeness. And that just takes time. And, you know, our brain sort of rewires. A lot of emotions are formed in our brains. It's connected. So, you know, we need it to give ourselves a chance to like still feel close, but adapt to the fact that, you know, it will never be quite the same. However, we still have a relationship with that person, right? Their memories and how they touched us.
Beautiful. Thank you so much, Ali. And I appreciate that there is no one right way to grieve, and that everybody is going to experience it differently. And as you pointed out, where there has been that lead up, it might be quite different versus something that comes on a bit more suddenly. So thank you for that. This next question is also for you, Ali. It has been almost a year since my daughter passed away. I missed her terribly and cry often. I find it hard to enjoy the things I used to enjoy, including time with my family and friends. How long will the grief last?
Thanks, Paul. That's another question I get often, you know, when is this over? I think sometimes we need to really tune out comments from others, even if they're well-intentioned. You know, people will sometimes be like, oh, you're still upset about that, or, you know, I don't know, things that sort of make us feel rushed. So especially in the case when you lose a child, I think that is more traumatizing often. It sort of feels like out of the natural order of things. So it's absolutely normal to still be crying. You know, a year after a year, that's really not that long. In the Victorian era, actually, people would often wear black for 1 to 4 years after the death of a loved one to signal to other people that they needed, you know, respect and to be left in that space to grieve. I think in Western culture, we often do want to rush things, which is, you know, to some extent contributing by internalized capitalism. You know, we get often 2 weeks of paid time off work when our husband dies, for instance, which is not enough time. So I think, you know, in the case of someone dying that's this close to you, you get to a point where, you know, you accept that life will never be the same. You don't move, you don't get over it, you don't move on from it, you just move forward and you relearn how to live life without them. So I would definitely encourage someone going through this to seek professional help. You know, there are bereavement group supports. Sometimes we do need some extra help to be treated for symptoms of depression. But yeah, in short, like it's very, very normal and very okay to still be crying after a year.
Beautiful. Thank you so much, Ali. Amy, this next question is for you. My brother is the executor of our father's will, and he's dealing with the estate. What about things that fall outside of the will? I believe my father designated my siblings and me as beneficiaries of his RRSP. Who deals with that?
That's a good question, Paula, because sometimes it can be confusing and who is responsible for it. And it's not just the beneficiaries or potential beneficiaries are confused, but sometimes the financial institutions have differing messages, which can be confusing as well. So the short answer is the executor is responsible for managing all the assets that fall into the estate. If there are designations in assets like an RRSP or the RIF, which is just an RRSP that's aged into a RIF, or the TFSA, those sometimes can have designations that are not the estate, but just a person. Insurance policies often fall to a specific designated person that is not the estate. Anything that goes to a person that is not the estate is not the responsibility of the executor. It's the person who is the designated beneficiary that can go and take the steps to have the monies paid to them. Sometimes the institutions want to talk to the executor. If you're on good terms with your brother, hopefully that's not going to be a problem. But technically, you just need to provide the information back to the financial institution or wherever the money is coming from to identify yourself and receive the funds. So ideally, you can do that yourself as a designated beneficiary, but if you need to enlist the executor, that might be the quickest and easiest way to proceed.
Super. Thank you so much, Amy. This next question is for Allison. Before she died, my wife had a whole life online, including her banking, automatic payments, email, and social media accounts. What should I do to close them down?
This is a great question, and this is an issue I run into frequently in estate administration. I think it's something where planning can be a great help. Because this does get a bit complicated if the person has already died and we're not really sure what sorts of accounts they have set up, which financial institutions they may have been dealing with, how to access those things. So assuming we haven't done any planning regarding this, after someone dies, you should first try to figure out what financial institutions they have been banking with. If you don't know what the financial institutions are, it is possible for you to get the assistance of a lawyer to do some of that due diligence for you. And then once you've figured that out, you should definitely let the financial institutions know that the person has passed away. They may want to see a death certificate. At that time, they will freeze the accounts. You won't be able to close down the accounts unless and until you have a grant of probate or a grant of administration. So it may be some time before the accounts can actually be closed down and then consolidated into an estate account and eventually distributed to the beneficiaries. With respect to social media and email, that's even more challenging. There are some social media platforms where there are planning mechanisms in place. For example, on Facebook, you can designate somebody called a legacy contact, and that person is allowed to access certain parts of your account once you pass away. But for other social media platforms, it's not super clear what happens after somebody passes. So it's important to review the policies of each individual provider that the person was using, and to determine if and how those accounts can be shut down. And so I would say you can expect that you will probably at least need a death certificate, and you may need a grant of probate for that as well.
Wonderful. And Allison, just curious, do people have these conversations and before they pass? Like, would it be common for example, the husband to have spoken to the wife in advance to ask, what are you, what social media are you on, or what accounts would he then step into to close? Is that something that happens?
Yes, so I encourage people to, in addition to, as I discussed before, providing a list of assets and liabilities that they have to their executor, to also provide a list of social media accounts, let them know not just what assets they have, but where they're located. So with what financial institutions and stuff like that, You might even want to keep a list of your passwords if it's something that you want someone to have after you pass. You might even want to keep a list of your passwords like in a lockbox or somewhere like that. Definitely a lot of time and expense and stress can be avoided by planning in advance for dealing with the online world.
Thank you so much, Allison. Amy, this next question is for you. I lived with my partner for 10 years before he died last month. I want to apply for the CPP death and survivor benefits, but his estranged wife has told me that she is applying for them. Who is entitled to the benefit?
Thanks, Paula. And this is a small piece of the issues that I see as something that might happen in this administration, because as a spouse, you have certain rights for the estate, to access to the estate, and people who are in fact married but separated, they may be at law designated or identified as not the spouse. And similarly, if you live with somebody in a marriage-like relationship, you can be seen as a spouse and qualify as the spouse for certain different aspects. So it's going to depend on the legislation, the length of time you have to live together. Generally, for most things in British Columbia, it's 2 years. You have to be living together in a marriage-like relationship. But to qualify for the CPP benefit, it's only 1 year. And so, leaving aside all that might be happening in the estate, and is this person still a spouse, or am I the spouse, or are we both spouses? Because it may be that you are technically both spouses in the circumstances. Looking specifically at this question, how do I get that money if I am the person who's been living in a marriage-like relationship, sometimes called a common law relationship, for 10 years? If you just go online, you'll see, you can Google, I think it's CPP survivor benefit form, and you'll find there's a form that you would fill out as a statutory declaration to set out your relationship. And as the person living in that marriage-like relationship, you would have priority. It would be you that would get the pension, and not the spouse, the ex-spouse. So it's going to depend on your circumstances, but certainly it sets out, and the form is easy to understand, and you need to just fill that out and submit it.
Beautiful. Thank you so much, Amy. Amy, while we have you, and I'm just looking at the Q&A, there's a question here. What is the difference between a representation agreement and an advance directive for mom?
Yeah, that's an excellent question. And in fact, I know that one of the earlier presentations I did with one of my law partners, Zach Murphy-Rogers, addressed those. And I know that People's Law School has a lot of excellent materials on these different types of documents that are relevant to end of life or planning. But the difference between it is the representation agreement is the document where you appoint somebody to be the decision maker for you for your personal or healthcare decisions that you can no longer make. So if, for example, you have dementia and you know that eventually you're not going to be able to make your own decisions, you can create a document, sign a document that appoints your spouse or your child, or more than one person, your 2 children, to be the person who makes your decisions for you. The advance directive, that's actually something you can look up online as well on the BC government website. It's excellent materials there for you to look at. And that gives direction on what you would like for your end of life care. Again, if you're not able to make those decisions yourself, you're able to set them out in advance so that it's clear for the people who are making your decisions for you when you're no longer able to, what you would like.
Beautiful. Thank you, Amy. And we will provide, I noticed there's links in the chat for the webinars that we hosted previously, and the one with you and your colleague, Zach Rogers, was excellent on representation agreements, as well as other resources. And we will link to those with the recording of today's webinar for anybody who would like to have links in the future. Alison, I'm going to follow up on a question. You've responded to the question, but I'm going to revisit, because there's a question here about, is there a specific, this is about the online passwords and so forth, is there a specific form or suggestions of how to deal with passwords for devices and online accounts? I just had an experience where so much of the personal information was kept on individual computers, but they died suddenly and nobody could access important information.
Sure, yeah, I'm happy to answer that. So, I mean, the first question to ask is, do you want anybody to have access to your personal information on the computer after you pass away? For some people, the answer to that may be no. Like they don't want people going through their stuff at any point in time. But if you are comfortable with having your executor having access to your personal computer or perhaps your cell phone, then I would suggest creating a list of passwords. There's no specific designated form for doing this, but creating a list of passwords and just putting it in a really safe place. So that may be a bank box or a safe in your house. It's really about your level of comfort with safety and privacy versus creating a situation that's going to be convenient for your executor.
Great. Thank you so much, Allison. There's a question here. I will ask you and see if you have the answer. My sister is under the care of the public guardian and trustee. She has a will, but I don't know who the executor is and she won't tell me. In the event that she predeceases me, what happens?
Do you want me to answer that, or is Allison answering?
If you're able to respond, I wasn't sure because of the public guardian trustee aspect, but if you're able to answer, that would be great.
It sounds like your sister isn't able to manage her own affairs, so the public guardian is being the substitute decision maker, which is fine. There is no obligation on a person to tell anybody what their will is before they pass. Wills only become effective after death. When somebody dies, then everybody who is named in the will gets a copy of it. So the public guardian should, if they have the document, should send it to you, notify you. And then as well as anybody who would inherit on an intestacy. An intestacy is where there's no will, and the government has set out who is going to inherit on an intestacy. It's like your close loved ones, family. And so there's no way really that you can obtain it in advance of her passing, but you should get a copy when she passes if you're named in the will or if you are one of the people who would inherit on intestacy.
Excellent. Thank you so much. Another one of the questions that has received a number of upvotes is, should a joint bank account be created for sibling and mom?
Allison, do you want to grab that?
Sure, I'll answer this one. So generally we advise against doing this. Most people think that if you create a joint bank account, there are two reasons people might do this. One is for convenience. Maybe mom is having some difficulties getting around and she needs a little bit of help paying for things. And so for convenience sake, son or daughter is put onto the account. The other reason people might do this is because they think when mom passes away, the money will just pass over to the sibling without probate, and that will be an easy way to get around things. So we can actually see a lot of complications with this, and the main reason is that in our law, we have something called a presumption of resulting trust. Now, just what that means is that if a person is added onto an asset, but they haven't actually contributed anything to that asset, then the law assumes that they're holding it in trust for the person who did contribute to it. So what that means is that when mom passes away, there's going to be an assumption that that bank account is being held in trust for the estate. So it doesn't actually end up passing outside the estate in that easy way that we think it's going to happen. One way to deal with that is to document the intention. If there is an intention for mom to make a gift of that bank account, then there are legal documents that can be prepared to reflect that. But whatever the intention is, whether the intention is for it to stay with mom or for it to go to the son or daughter, it should be documented. And just to be aware, it's not as straightforward as it might seem. Amy, do you have anything to add to that?
No, I will say that in families where there are those fractures that I talked about, It's really important to be very clear on that, because there is a lot of litigation that happens after death to try to get assets back into the estate. Sometimes if the family is all on board and there are no fractures, or if there is only one child and no spouse, maybe that's going to be workable from your perspective, but be mindful of the likelihood of dissension or fracturing family relationships over something like that, and make sure that it's correct for your circumstances.
Beautiful. Thank you so much, Amy and Allison. Ellie, we have a question here. Are there tips, guidance for people who are losing loved ones to diseases such as Alzheimer's, cancer, high-risk lifestyle, etc.? It seems this stage of the grieving process could be a bit different since the loved one is technically still with us.
Thanks, Paula. Yeah, I think that one, it can help to grieve with other people who know this person. If you are close with your siblings or the other parent potentially, really just talking about it is what you can do. I think also, keeping in mind the basics like eating well, sleeping, exercise, doing everything you can to sort of keep your own spirits up. But yeah, there's no secret key, unfortunately, to that.
Beautiful. Thank you so much, Allie. Another follow-up question for Allison. When you mention a list of the debts and assets for probate application, how detailed, what level of detail is required? Assets as in bank accounts and property, or even items of value in the house?
Sure, happy to answer that. So the level of detail is a lot. So basically the reason that we're doing this is, as I mentioned previously, it's when you make a probate application to the court requires that we file something called a statement of assets and liabilities. And the statement of assets and liabilities has to set out all of the assets of the deceased, including things like household items, furniture, and it also has to include their value as of the date of death. So the more detail, the better. We need to provide information about the location of any assets, information about from the land title office regarding any real estate. So a lot of detail, yes, and it does need to include anything that's passing through the estate. And so just a brief note on what is passing through the estate. Things like registered investments that have designated beneficiaries, so things like RRSPs, TFSAs, those will not pass through the estate. And anything that's held in joint tenancy, like true joint tenancy, for example, if your mom and dad own a house jointly, and mom passes away, that house will just pass to dad and it won't pass through the estate.
Beautiful.
Paula?
Thank you. Yes.
Before you go in, can I say the one thing that really I think a lot of people that I've met are in my work are surprised at is that there isn't really a lot of commercial value to a lot of the possessions of a loved one. And so, for example, while you do need to list the household contents, honestly, you would be surprised at the value. So oftentimes it is just household content. It's really what I see a lot of are if there is artwork that's quite valuable, like separately insured type artwork or jewelry, or people have coin collections or stamp collections. Those ones we see with values. But Allison, I don't know what we usually put for household contents unless they have like fancy antiques. Is it sort of more of a nominal value, or do we see big values for that?
Yeah, it depends. It is something where usually we would let the person sort of give an estimate unless there is something that we know is really valuable. Sometimes it is nominal, so we would say, maybe it's worth $100. But yeah, it depends. Some people have really significant value, even just in furniture. It's surprising to me. Yeah.
Beautiful. Thank you so much. Allie, I have a question for you here about resources. Do you have any resources, books, podcasts, etc., to help dealing with grief?
Yeah, there's I don't have any in front of me right now. I think hopefully we can list or put those up somewhere for people to access, but there are many YouTube videos, TED Talks, podcasts. If you just sort of Google grief and loss, there's also a lot of people who specialize in grief and loss. So I would definitely encourage you to find a counselor who does specialize in that if that's what you're looking for.
Beautiful. Thank you so much. And yes, we can put links in with the recording to any resources that you'd like to recommend. Alison, following up on this list of assets, for example, one of the questions here is it possible to donate costly medical devices such as hearing aids and an insulin pump? How is this done? Is it similar to organ donation? I'm not sure if you have any insight into how you might proceed with something like that.
Yeah, I'm not actually sure about how you would go about donating something like that. But I would say that for the purposes of that list that you file with the court, it is all of the assets at the date of death. So even if you had some medical equipment that was quite valuable and you disposed of it after death, it would still need to be listed on that list because it's the date of death value of that.
Beautiful, thank you. And there is a question with a lot of upvotes. Are there any free or low-cost services for funerals in British Columbia that you're aware of?
I don't have the answer to that.
I do know that if the estate has insufficient funds to cover a funeral, you can make an application for government funding. But beyond that, I'm not really sure. Yeah.
Excellent. There's a question here. My father is in a care home and I have no power of attorney. Can I still legally advocate on his behalf as his daughter for equitable end-of-life care?
So remember that the power of attorney document gives you the power to make legal and financial decisions for the person who gave it to you, so for your parent. But it's the representation agreement that gives you the power to make medical and healthcare and advocate for healthcare decisions for your parent. So they're two separate documents. There are two different levels of a representation agreement, and it may be that your dad has capacity or your parent has capacity to do one of those, because you don't need a really high level of capacity to do that. So that would be something that I would explore and find out whether or not that's something that that is possible for him to make one of those for you. There's probably more steps that we could talk about, but I think that would be probably the first step for you.
Beautiful. Thank you so much. And I wanted to acknowledge all the questions that have come in. Thank you, everybody. I've been prioritizing based on upvotes and the ones that are most closely related to the topic that we're covering. There are questions that cover probate and next steps, and we will be having a webinar upcoming on December 5th to address some of those questions. So please do return back if we haven't addressed your question. Another question that has come in is, what are your thoughts on choosing a bank or financial institution to be an executor? And if you do so, do you need a lawyer as well if you go with the financial institution as an executor?
Yes, go ahead, Alison.
Sure. So I frequently work with trust companies that all of the big financial institutions have trust companies that can act as an executor. Usually we see these trust companies appointed in situations where an estate is of a significant size and where there's going to be some complexity. It might also be appointed because there's going to be a testamentary trust in the will that's going to run for a very long period of time. And we might be concerned about an individual's ability to manage the trust for that period of time. A trust company may also be appointed in situations where There is no person that is available to act as an executor, or whether there's concern that appointing a family member might cause some sort of conflict. And so those are all reasons why you might want to appoint a trust company. And then what was the second part of the question?
Whether you would still need a lawyer if you were to appoint a financial institution.
So I'm assuming that's, would you need a lawyer for the probate aspect of it? And so the answer to that is yes. And we do have trust companies that come to us for our assistance in preparing the probate application and getting probate. So those two roles, the executor role and the legal counsel role, would still be two separate roles.
Beautiful. Thank you so much, Allison. And thank you to all of you for answering these questions. It's wonderful. We've got time for one last question, which is the spouse still the next of kin if they are only common law and not married?
Yes.
Beautiful. Thank you.
There's no distinction between a legal marriage and a common law relationship, a marriage-like relationship. It's the same thing. You're still the spouse.
Beautiful. Thank you so much, Ali, Allison, Amy. It has been such a pleasure having you here today. Thank you again for all of your help and for this excellent presentation.